Thank you very much. Thank you for your patience. I once went to a lecture in which the lecturer wanted to give an example of a simple procedure. Next slide. So he spoke about boiling an egg. He said something like this: to boil an egg, you put water in a pan, bring it to a boil, and put the egg in and wait for 5 minutes. Now, that seemed a reasonable description. It also seemed that the process that he was describing was a simple one. However, someone put up his hand and said, but you need to watch the pan to make sure that the water continues to boil when the egg is added and that it doesn't boil over. Another person says you need to add salt to the water. Other comments included, I like my eggs boiled for 4.5 minutes. And how long you put the egg in the water depends on how big the eggs are and what sort of eggs they are. In the end, someone put up his hand and said, this is all too complicated. Can't we think of an example of a simpler procedure than boiling an egg? Now, this illustrates a fundamental point about the way that judges develop the law in England and in the Anglo-American tradition. A judge may present in a decision a principle that is valid in general. When the lecturer said what he said about how to boil an egg, he was saying something that was generally true. But the principle that he stated would need clarification and elaboration. There may be special circumstances in which a general principle does not apply. And all of this needs to be developed in the future. Next slide, please. Judges in the Anglo-American tradition would not say that they make the law. They would say that they interpret law that is already there and apply it to new circumstances. I'll be coming back to this. And of course, I should make the point that almost all people know, which is that what distinguishes precedent in the Anglo-American tradition is that principles established in decisions of higher courts are binding as a matter of law on the lower courts. Higher courts make a finding in a specific case which establishes a principle that is applicable in many other cases in the lower courts and should be applied in those courts as a matter of law. To understand how precedent works in the Anglo-American tradition, it's probably best to look at a relevant decision. I'll take an example that is almost 200 years old. Next slide, please. Adams and Lindsell from 1818, which concerns contracts that are made by letter. This is an area of the law that is entirely governed by decisions of the courts and not at all by legislation. I chose this case because, like the lecturer I told you about at the beginning, I thought it would be simple. But as in that example, the more closely one looks at the situation, the more ramifications one becomes aware of. A typical situation, and the situation in this case, Adams and Lindsell, is as follows, and it's on the screen in front of you. A sends B an offer by post, B receives the offer, B posts an acceptance of A's offer, and A receives it. The question: at what point is there a legally binding contract between the two parties? This matters not only because it determines when the contract has been made, but also where it is made. Is there a legally binding contract when B posts his letter of acceptance to A, or when A receives B's letter of acceptance? The basic position in English law has been, perhaps surprisingly, that there is a contract at the point at which B posts his letter of acceptance to A. That is, before A receives the letter of acceptance. Every English law student learns that this principle rests on the case of Adams and Lindsell from 1818. The principle is in fact still binding on the courts, and the decision is only a page in length. It does make reference to earlier decisions of the courts, but not to any legislation, because there was and is no relevant legislation on this point. The critical part of the decision is contained right at the end in a few sentences of reasoning, which in fact is based on common sense and not on anything else. But first, I should tell you the facts. Next slide, please. The case concerns the offer by a seller of wool to a buyer of wool. On the 2nd of September 1817, the defendants sent the plaintiffs a letter offering wool for a certain price. The offer of the defendants stated that the plaintiffs should reply in the course of post. This means that the offer required that the plaintiffs should reply as soon as possible. Owing to a mistake by the defendants, the letter of offer reached the plaintiffs later than expected at 7 o'clock on the evening of the 5th of September 1817. Later that evening, the plaintiffs sent a letter of acceptance to the defendants. So, the plaintiffs did reply as soon as possible, as required by the offer. However, the letter reached the defendants on the 9th of September, which was again later than expected because of the original error that the defendants made when they sent their offer. On the day before, the 8th of September, which was the defendants who had not heard from the plaintiffs as expected had sold the wool. The plaintiffs said, hang on, you should not have sold the wool on the 8th of September because there was already a legally binding contract with us on the evening of the 5th of September when we sent off our letter of acceptance. The defendants said, no, no, there could be no legally binding contract till we actually received your letter of acceptance. But by that time, we had actually withdrawn our offer because we'd sold the wool to someone else. Next slide, please. The court found that the defendants were wrong on both points. It found that there was a legally binding contract at the moment that the plaintiffs accepted the offer on the evening of the 5th of September. The sale of the wool to someone else did not somehow nullify the offer to the plaintiffs. How did the court reach these findings? Next slide, please. The reasoning is essentially given on that screen ahead of you. There are 3 points, and the third is the most important. It's a somewhat contorted sentence in English, and my colleagues have done a great job of translating it, and I'll read out what in fact it says. If there could be no binding contract till the plaintiff's answer had been received, no contract could ever be completed by post. For if the defendants were not bound by their offer when accepted by the plaintiffs till the answer was received, then the plaintiffs ought not to be bound till after they had received the notification that the defendants had received their answer and assented to it. And so it might go on ad infinitum. The reasoning here is very brief, but it has been repeated in other decisions of the courts in common law jurisdictions over the decades. And I shall now very quickly give examples of how the principle established in Adams and Lindsell has been applied and developed over the years. Next slide, please. 30 years later, incidentally, after the introduction of postage stamps in the UK, Dunlop and Higgins of 1948 concerned a letter of acceptance that was delayed by a severe frost affecting the mail. It was held that the principle established in Adams and Lindsell applied in that case, and that the contract was legally binding from the time that the letter of acceptance was posted. The same principle was applied in Henthorne and Fraser in 1892, in which the offer was not made by post. A 20th century case, N. Torres Limited and Miles Far East Corporation from 1955, again reaffirmed the rule on contracts made by post in the previous cases, but went on to find that a different principle applied where contracts were made by instantaneous methods of communication, such as telex, a form of electronic communication which has now been superseded by fax and email, and so is no longer used. The principle, however, was that in such cases, the contract is only legally binding when the acceptance is received by the offerer. So in those cases, a different principle was adopted. Next slide, please. I'd like to go back 2,500 years ago to Aristotle's Nicomachean Ethics. And the quotation there, I think, speaks for itself. When the law speaks universally, and a case arises which is not covered by the universal statement, then it is right where the legislator fails us and has erred by oversimplicity to correct the omission, to say what the legislator himself would have said had he been present, and would have put in to his law if he had known. This point, I think, has come up several times already in the course of the presentations today, and it can be used to explain the operation of judicial precedent in the Anglo-American tradition if it is reformulated in terms of courts making legally binding decisions. A court decides a case, and when making a decision will indicate the principle that is being applied, but in future cases will come up which would lead the same court to qualify the principle it applied in the original case. That is how, at its best, judicial precedent operates in the Anglo-American tradition. All that courts should do is adapt approaches taken by courts in the past in ways in which those other courts would have done had they been confronted with the present situation. Where does all this lead us? Next slide, please. Judicial precedent, in some form or other, is important in most legal systems to ensure fairness and consistency, though in many, of course, it is not legally binding. In any legal system in which judicial precedent functions, one needs an institutional structure that promotes its efficient operation. This depends in part on the mindset of the judiciary and others working in the legal system, and in part on the organization of the courts. This is as evident in the Anglo-American tradition as it is elsewhere. Just one final reflection on the basis of what has been said so far today. The Anglo-American approach to precedent is, of course, very different from comparable legal practices in continental Europe. But there are convergences. Both systems have to deal with the infinite variety of human situations, and both adopt rule-based approaches to those situations. Thank you very much.